Hello, everyone, and welcome to
Hello.
our webinar, GDPR after Brexit. We created this webinar because us reached a lot of questions. How will it go on? What will happen after the Brexit? And we have here our specialist, Rob Mason, in order to explain us this. One second. So, my name is Lisa Hoffmann. I'm the Prida Tech DPO and in charge of the international data privacy. And we have here Rob. Thank you so much for being here,
Okay.
Rob. Rob
Pleasure.
is an
Hopefully,
experienced UK data protection specialist and helping clients to navigate GDPR compliance, especially in the face of Brexit, right?
Indeed. So,
Perfect. So happy to have you here, Rob.
thank you.
So the agenda of today is GDPR after Brexit. So we will see what changed in the data protection laws. How does Brexit affect the existing data protection laws on the UK side? What happens to data transfer and data storage? And how data transfers between the UK and the EU will be affected? And also, what do you have to do? And what do you have to consider in terms of data storage? Also, we speak about the UK representatives also in the European Union, and when do you need to appoint one, and what is its function. So, first of all, we are all aware that the General Data Protection Regulation applies to all companies based in the EU and those with EU citizens as clients. So the UK still will need to comply with the GDPR. First of all, of course, because we have and we are now in the crossover period, but also second, because the UK companies, a lot of UK companies have EU citizens as their clients and therefore still need to comply with the GDPR. So what will happen? We speak about how the data is stored and transferred and processed between the UK and the rest of the EU and how this will change. And of course about how the UK will have to demonstrate adequacy and showing the EU that the data is processed safely in the UK. You won't need to appoint an EU representative during this transition period, and the data will of course continue to flow, but we will speak about what changes after this transition period, and yes, what you need to consider in this case. Also, the GDPR will be incorporated into existing UK data protection law, hopefully under the UK GDPR. So you should take steps now to ensure that you're compliant. If you found a new company, if you're already established company, you still should be GDPR compliant. So Rob, let's get started now with my questions for you. So which laws will change? Do I as a company have to comply with the UK privacy laws and the GDPR?
Okay. Well, I think it probably may be useful if we just take one quick step back and kind of work out why it is that we're here in the first place. Obviously, the UK held its referendum on membership of the European Union back in 2016. We made a decision to leave the EU based on a 4% difference between leave and remain. And therefore, the UK government triggered Article 50, which was part of the European Union's Lisbon Treaty. And we started the process, a 2-year process at that time, in order the week that we now call Brexit, which meant that the UK was supposed to leave the EU on March the 29th, 2019. That, of course, got delayed to the 12th of April initially, and then to the 31st of October. But we finally got around to it, as I think we're all fairly aware of, on the 29th of January this year. Now, the important part of that is that what that has begun is a transition period which will last about 11 months. So if all things go to plan, then the UK will essentially officially depart from the EU on the 31st of December this year, so 2020. Now, in the most part, during this period, up until December 2020, it is business as usual. And it is possible that we can extend that period up to another 2 years. So now, obviously, Boris Johnson, our Prime Minister, is very keen to see us get Brexit done. And therefore, up until obviously the events of the last couple of weeks, it was fully expected that we would entirely leave as of the 31st of December this year. But we'll have to wait and see kind of where that comes. So after this point, there's still very many unknowns, other than the fact we know we will eventually now come out. But we don't exactly know on what exact basis we'll be coming out on, because the negotiations that are currently being conducted will decide the environment and the decisions and the deal that basically gets done. The expectation is that many of the EU laws will simply become UK laws, but not all of them. However, one of them that we are expecting to become a UK law is the EU GDPR. Now, in simplest terms, what it means is that we published a bill called the Data Protection, Privacy and Electronic Communication Amendments Regulation in 2019, which will essentially make the UK GDPR, the EU GDPR will become the UK GDPR, essentially verbatim to the EU GDPR. So we'll have effectively two GDPRs running at one time. And so that's the kind of environment that we'll be dealing with. The United Kingdom Data Protection Act, which is the act that the UK used in order to bring the GDPR into UK law in the first place, will simply be amended to point to the UK GDPR, whereas at the moment it effectively points back to the EU GDPR. So, from the way it currently stands, from a practical perspective, the UK GDPR is identical to the EU GDPR, and therefore, if you transfer data to and from the EU, then you are going to need to consider both the EU GDPR and the UK GDPR.
Okay, wow, that's a lot to consider. So for you, how it looks right now is that you're going to leave at the end of this year, or things are changing a bit?
Yeah, I mean, the plan was obviously until COVID-19 got in the way, but certainly that the plan is to leave. As I say, we do have this possibility to extend it, which may be taken. But I think all organisations should be preparing for that hard kind of that point, that end point being the 31st of December. If it gets extended, then fine. But all of the steps that need to be considered, as I'm sure, be going through in the rest of these slides, they should be considered now, not necessarily leaving it any later on the assumption that the actual exit date will be delayed. Absolutely,
good to know. So what happens when the UK becomes a third country? This is a very important question, because right now we are facing this adequacy decision and of the European Commission. So what can you tell us about it? How far along is it? What is your opinion about the adequacy decision? What will happen there?
So I think the first thing is to understand what a third country is. So a third country is essentially any country outside of the EU. So which is therefore will be the UK once Brexit is complete. So we are becoming, regardless of the adequacy decision, we are becoming a third country, and therefore we have to act like one under data protection laws and EU data protection laws. So now, how much of an issue this is for UK organisations will depends on the data transfers that you are currently party to. So if you're not transferring anything outside the EU, outside the UK, then of course it's not going to affect you greatly. But what a lot of organisations sometimes forget is that it's very easy to export data outside of the UK. I mean, saving a file to, I don't know, Dropbox or something like that it is effectively exporting that data depending on where the servers are that are physically located for that particular provider. So lots of cloud services, it's not always entirely clear which jurisdiction or which geography that the physical servers are that the data will reside, and that's what matters. And so it's important that, as we're going to come on to in terms of doing a data flow mapping and making sure that there's a clear understanding of what the arrangements are. So now in terms of adequacy, adequacy is a mechanism that is decided upon by the European Commission. So it is a process that the Commission goes through with a country to ascertain whether that particular country's laws in general, but I mean data protection laws specifically, but laws in general largely provide the protections available in that country that are equivalent to those in the EU. And so those decisions are based upon GDPR Article 45. So they're all kind of, to a degree, mapped out in Article 45 as exactly what a country needs to comply with. But in terms of the UK, it's by no means guaranteed that the UK will get adequacy as a result of the negotiations that are currently going on. If we're not considered adequate by the 31st of December, even if it's only temporarily, because the decision takes longer than that period of time, then all transfers to the UK will require additional safeguards to be put in place. So these safeguards, if you're exporting data at the moment, if you've got data maps, if you're sending data to, I don't know, India and Australia and Singapore, then you'll be reasonably familiar with these safeguards because you will have been putting these kind of things in place already, because they are not considered adequate countries. And so, but if these are new to you, then there are certain things that you're going to need to do with all of your partners and suppliers and vendors in those countries with whom you are exchanging or transferring personal data, not just data period, but personal data. So where a country is considered to be adequate, which the UK is not yet, it means that transfers can be made on an unrestricted basis. Okay, so the extra safeguards don't need to be put in place. Now, there are quite a number of countries that have already been deemed adequate by the Commission, and my understanding is that the UK will recognise those countries as adequate. So whatever you've been doing in terms of under EU regulations, you can continue doing under the UK. So we're not going to have to wait for separate adequacy decisions of the 12 countries that have already been deemed as adequate. And it's Andorra, Argentina, Canada, the Faroe Islands, Guernsey, Israel, the Isle of Man, Japan, Jersey, New Zealand, Switzerland, and Uruguay. So quite a kind of strange mix. We should get South Korea becoming adequate before the negotiation period ends. And the US I'll probably deal with a little bit later because there's a special case for them. So adequacy doesn't require identical data protection laws, but those laws must provide what's called essentially equivalent protection. Okay, so what we mustn't forget is that adequacy is beneficial to both the EU and the UK. So, there's a lot of organisations in the EU that would like to see the UK becoming adequate, and obviously vice versa. And the reason for that is because it allows the free movement of personal data without the need for these additional individual safeguards that you're going to need to put in place with every single vendor, supplier, partner, whatever it is that you exchange personal data with. But it is by no means a done deal. And the reason, one of the many reasons why it's not a done deal, is because we have this thing called the Investigatory Powers Act of 2016. So the IPA has been described as the most extreme surveillance legislation ever passed in a democracy. And it's likely that because of that, it is going to fail the general and indiscriminate collection test that the Commission will be conducting. And so but people ask me, quite regularly, on the 31st of December, we're adequate, or we're part of Europe, so we're considered adequate. But on the 1st of January, we won't be. How is that possible? But that is predominantly because under it's Article 4 of the European Treaty, national security remains the sole responsibility of each member state. So whilst we're part of Europe, the likes of the Investigatory Powers Act is ignored in that decision making, but as soon as we come out, it becomes a factor, and therefore, because we come out on the 1st of January, potentially, then of course it has to be taken into account as a result, and therefore, it's likely that the UK is going to need to amend the necessary laws to provide the appropriate assurances that the Commission is going to require as a result.
Absolutely. Thank you so much for this explanation. Yeah, let's see if the Investigatory Powers Act contravenes with the human rights element so much, which the GDPR fundamentally is based on. I also hope that the UK will be found adequate, as you see, it also has a lot of impact on the European countries dealing with the UK. They would have to maybe update their privacy policy, implementing the dealing with a third country. If they weren't doing that before, they have to find other measures according to 44 GDPR and the following, like binding corporate rules or appropriate safeguard code of conduct. So we all hope you will be fine adequate.
Indeed.
So so what effect would there be on international data transfers?
So the first question that you're going to need to ask yourself in terms of international data transfers is, are you making this thing called a restricted transfer? So if you are, so if you're making a transfer to a country that isn't considered adequate and so on, then that will be classed as a restricted transfer. And so the transfer will require additional safeguards. So if you need to move your data, so one of the questions is, do I need to repatriate effectively my data that is currently in Europe? Do I need to move it to a server that is based in the UK? You need to consider what the regulation is basically saying is you need to consider whether you can achieve your aims for that data transfer without transferring it out of the country or on a restricted transfer basis. So if it's possible and it's easy and it's reasonable for you to log into your Amazon Web Services backend and effectively just change the region tenant to the UK, and therefore all your data moves from, I don't know, Germany to the UK, then you would be expected to do so. However, if that is not as straightforward as that, then you are going to need to put appropriate safeguards in place in order to enable it. But we're not going to be stopped from doing it. So it's not a kind of prerequisite of Brexit that you have to kind of repatriate all of your data. But anything that is not reasonable to do so, then you're going to need to put those safeguards in place. So the advice very much is that you create a data flow map. You must understand what data you've got, where it's stored, who has access to it, what your lawful basis is for processing it, and all these kind of things that you're going to need to conduct that process so that you can answer whether your data is it's located in an EU member state or what's called the European Economic Area. So that's the current 27 member states plus Iceland, Norway, and Liechtenstein. So, or is it located in one of the 12 adequate countries that I mentioned earlier, or is it subject to Privacy Shield, which is the code of conduct in the US, or another code of or based on another code of conduct? And I'll talk about the Privacy Shield probably in some more detail in a second. Or lastly, does a specific exception or derogation apply? So, and those kind of exceptions are in medical emergencies or national security and that kind of thing. So it's outside of the other options. But in the vast majority of cases, organisations that need to make a restricted transfer will do so using what are called standard contractual clauses. And these need to be, these are legal clauses that the EU devised quite some time ago. They're actually based on the old 95 directives. They haven't even been updated for GDPR yet. That is coming. But they're still deemed to be valid even in the GDPR world. So as long as you have included those standard contractual clauses within inside the contract or agreement, either separately or as either embedded or as an annex or appendix to that agreement, and of course the organisation agrees to be bound by them, then that legitimizes the transfer of that data to that restricted country. So that's by far the easiest way of doing it. There are other mechanisms. There are these things called binding corporate rules, but they're generally there only for intra-company transfers for large organisations, because BCRs are quite expensive and very time-consuming to get into place. So for the most of us, SCCs are the mechanism that we need to use. And so you do need to identify your data map, identify everybody, every organisation that's involved in the data flows, and make sure that those appropriate controls and safeguards, most likely using SCCs, have been put in place between you and them. There are some issues. There's a slight kind of gap in that there are controller to processor SCCs. So if you're the controller, you're sending data to an organisation in the EU, which they're processing on your behalf and either giving you back or doing something with it, then you would put the version of the SCCs that are relevant to a controller to a processor. And of course, you can have it the other way around. But the problem is that the UK will deem the EU adequate. So we can transfer data to the EU, but we can't necessarily transfer it back because it's the EU that's making the adequacy decision on the UK, not the other way around. So there is this slight concern that we don't have processor to controller SCCs. We've got controller to processor, but we don't have them the other way around. And so there is a potential that data could be trapped in the EU because we can transfer it to the EU, but then they would need to have SCCs in place to transfer it back to us, but they can't do it. So there's a slight anomaly there, and maybe someone has the answer to that. But at the moment, that seems like a bit of a gap.
Okay, thank you so much. So let's speak a bit about the EU and UK representative, because this is a very important question. Also, we receive actually a lot. So when would I need to appoint one, and what would be its role? Would it be like a bit like the DPO? And what has the background to be? Does it need to be a legal background, a data protection background? What would be good there?
Okay, well, let's start with where it comes from. So the GDPR Article 27 deals with the need for an organisation to appoint a representative inside the EU if they do not have a presence within the EU. So you've got to be outside the EU. You've got to be processing data on EU residents, and you've got to not have an office or something in the EU. And if all those criteria match, then you would need to consider appointing a representative. Now, representatives need to be appointed irrespective of adequacy. So whether we do or we don't get adequacy, that doesn't have a bearing on whether you need to appoint a representative. So if you are, let's start with the easier scenario. So if you're in the US and you're processing data on EU residents, then you would need to appoint an EU representative if you don't have a presence already in the EU. But we are going to have this issue coming up because, of course, we've got the EU GDPR, and now we're going to get the UK GDPR, and therefore we've got two Article 27s. And so it will create this situation where EU organisations that are not present in the UK, but they're processing data on UK residents, will need to appoint a UK rep, and UK companies that don't have a presence in the EU, but we're processing EU data, will need to appoint a representative in the EU. So it's a kind of bit of a red tape thing in order to comply with those that particular article within the regulation. However, there are some exemptions, and so public bodies and authorities are exempt if your processing is only occasional and therefore does not present a significant risk to the rights and freedoms of data subjects, then you are exempt. Obviously, there's a grey line as to interpretation of what is considered occasional. And if you're not processing special category data, so that's medical, health, religious beliefs, that kind of thing. So as long as you're not processing that, then you don't need to appoint one. So, but what it does mean is that a lot of organisations will fall into that definition. So, but also the role of the representative, once you've appointed one, is to kind of facilitate communication between EU data subjects and your organisation. Now, that's very different to the DPO's role. So the DPO is there to be independent and act on behalf of data subjects, whereas a representative works solely based on a written mandate from the controller or the processor. So they are contracted to act as a representative, legal representative effect, for that particular controller or processor. So, and the European Data Protection Board has kind of suggested that organisations can't be both DPO and representative, although there are some ways of separating that, and it, of course, it's actually never really been particularly tested. But the representative, unlike a DPO, is there to cooperate with all of the GDPR supervisory authorities, so on behalf of the processor or the controller. They have an obligation to maintain your records of processing activities, which is a requirement under Article 30, which if you've got more than 250 employees broadly, then you need to be doing that. But in terms of representation, the representative needs those records in order to be able to represent you, because they need to understand your your processing activity. That's something that they will need to create, as a result, on behalf of that client, or the client will need to provide them for their European processing. And then that representative appears on their privacy policy as the contact point within the EU. Now, another big difference between a representative and a DPO is that a DPO essentially doesn't have any liability. Maybe there's a negligence issue, but generally they don't have any liability for the processing activities of the controller or the processor, whereas a representative does have liability. Again, it's all a little bit confusing in that the EDPB European Data Protection Board has suggested that it's not, that the liability isn't there, but you've got, I think, even countries like Spain where they've said that the liability does exist. So there is a potential and very significant liability put on the representative when they represent their client as who are the controller or the processor. But the key thing here is that we will have two. So EU companies, qualifying companies, will need to appoint in the UK, and UK qualifying companies will need to appoint in the EU.
Okay, for the liability, I see that a bit tricky now, because then, I mean, I would rather be the DPO with no liability than the representative. Yeah. So you think some companies will have like some trouble finding one?
Well, I think finding one isn't so much of a problem. And obviously, I mean, it's a service that we provide, but the key issue, is they have to understand data protection. They can't just be kind of an individual that creates a website and says, "Yeah, I'm a representative, sign here." So they have to be a skilled organisation. They have to have the experience and the knowledge in order to be able to deliver the service. But they also have to be prepared to take that liability. So it's very important that the arrangement between the representative and the controller or processor has an agreement in place where there are suitable indemnities put in place so that if a regulator should ever bring or impose a penalty on a representative on behalf of the client they represent, then that representative has the ability, ideally, to be able to or be indemnified by the client in order to deliver it. So obviously it's completely untested at the moment. We haven't seen any particular cases come up, but it's just another one of those slightly unanswered questions at the moment. So, but representatives do exist. It's a relatively reactive service, so you are kind of just waiting as the point of contact for a data subject or a regulator. So it's not like a DPO where they're being proactive about your processing and they're advising and guiding and putting a framework in place. The representative isn't doing so much of that. They're really just acting as a contact point. So their details will appear on your European-facing privacy policy as a point of contact, and generally they will triage any issues, any requests that come from either a data subject or a regulator, and they'll work out whether how the best way to respond, obviously in discussion with the client, is the best way in order to deal with that particular issue that's come up.
Okay, thanks. Then let's see how the situation will develop in the future. So yeah, speaking about liability, we also have to come to penalties. So there are penalties for GDPR breaches can and do happen, and fines can run into hundreds of millions. So the question is then, who can penalize me? Is it the UK? Is it the EU? Or is it both?
Well, so there's no change really. So in the UK, so obviously we're going to have effectively two versions of GDPR. So we've got two chances to be fined 20 billion euros or 4% of global turnover. Obviously, the 20 million euros becomes whatever that is in pounds under UK GDPR. So what it's going to come down to is, yes, you could potentially be penalised under the UK GDPR in the UK and in the EU under the EU GDPR. But it will depend on where the breach data kind of resided and who was affected. So, but it's not that different to the current situation. Under GDPR, we have this thing called the one-stop shop. So what it means is that when you have a breach and that breach potentially affects data subjects from multiple supervisory authorities' jurisdictions, you would nominate one supervisory authority as the lead authority. And that means that they are the authority that would deal with whatever the repercussions are for that particular. It doesn't have to be a breach, it can be lots of other things, but a breach is a perfect example. And so it's designed for organisations that have their main establishment in a single member state, but process data across multiple member states. So the situation for UK companies is that it's likely that at the moment, if you are conducting activities under one-stop shop, it's likely that it's the ICO, if this is where the processing is taking place. It's likely that the UK Information Commissioner's Office will be your lead authority. And of course, after Brexit, they can't be it because the ICO will no longer be part of, the UK is no longer part of Europe, and therefore the ICO won't play a part in the European Data Protection Board. Now, they might continue in an advisory capacity, but they won't be making decisions. And so organisations in the UK that are currently using the ICO as their lead supervisory authority under GDPR, they need to evaluate their processing in the other member states and establish, ideally, a new lead authority and then update their privacy policies to reflect that decision. The problem is that it's not always cut and dry, because if the vast majority of your processing is in the UK, there might not be an obvious member state, alternative member state, in order to nominate as your lead authority. And you can't just kind of stick your finger in the air and go, oh, let's choose that one, because the member state that you nominate, or the supervisory authority you nominate, needs to be where decisions are being made about the processing of that particular data. So you have to have a kind of administration point. You have to be the data that's being processed in that legal authority's member state has to be where the decisions are being made. And that was one of the problems that Google had. Obviously, they nominated the Irish Data Protection Commission as their lead authority, but the CNIL, the French authority, challenged that because they didn't think it was appropriate, because decisions were not being made in Ireland. They were obviously being made in California, and therefore they were challenged as to whether that was appropriate that they'd named them as their lead authority. So, what it means is that it opens you up to issues being raised by more than one authority. And so ideally, if you can find an individual supervisory authority to be your nominated contact point, then that would be that's ideal. But if you can't pass the where the decisions are being made, you just choose one. So you've got to be able to demonstrate that decisions are being made. And if you can't, then you won't be able to assign one, and therefore there's the risk that you might have to answer to multiple supervisory authorities whenever there's some kind of issue.
Okay, that looks a bit tricky, because yes, we saw so far with the adoption of the GDPR that some countries find it stricter, some are not yet into the finding. So it could also be that you select a bit in case of this. No, oh, this country, I see they didn't press so many fines, so maybe I select this one. So yeah.
So yeah, you can't just choose the one that offers the most favorable environment, put that way.
Exactly. Let's see. So yes, so you want to speak a bit about the actionable steps that must be taken right now with the Brexit, when in December the end is coming, about what steps a company has to take and how they have to go forward.
So I think the first step is understand your data. It's like it's the same kind of answer almost regardless in terms of data protection. Understand what you've got, because then once you do, you can make the appropriate decisions and act accordingly. So understand your data transfers. So if you are transferring personal data to the UK, what controls do you need to have in place? So are you going to be okay to use, for example, those standard contractual clauses within the contracts? Do they already exist? Are you going to need to go through an exercise of identifying all of the different partners that you work with and putting those controls in place? And so that's probably one of your biggest jobs. The second thing is, as we just talked about, is to review your lead authority. If it's currently the ICO, do you have the ability to nominate a lead authority realistically in the EU? And assuming we're not adequate, you're going to need to update your privacy policy to reflect the UK's third country status. There's some work that would need to be done either by your DPO or your lawyers in order to keep that up to date. You most certainly need to review whether you will fall in under the criteria of needing to appoint an EU representative. So, and vice versa, if you're listening from the EU, then obviously there's a possibility that you might need to appoint a UK representative. So, certainly understand the type of processing that you're doing, make sure, see if you do actually fall under that criteria, and then obviously, make some inquiries as to a suitable organisation that might be able to provide you with that representation service. You should be conducting, wherever the data that you identify in your data flow, certainly if it's involving sensitive data or special category data, then you should be performing a data protection impact assessment, so a DPIA. That DPIA will feed into your records of processing activities. That's the part of your accountability documentation. This is all kind of normal, if you like, GDPR compliance, but obviously you're going to need to think about it in the EU or UK context, depending on where you're particularly based. And then if you have them, then you'll need also to amend your breach notification protocols, because certainly from the situation, the one-stop shop, but also whether you have just internal policies and protocols for dealing with things like breaches, make sure they've been reviewed and updated accordingly.
Okay, Thank you so much. That was incredible, insightful. And while I go into the topic later, how you can ensure GDPR compliance in general, I just want to say to the audience that now is the time to ask also your questions to Rob. You can write them here below. So later he will answer them just after I finish the general part. So he's happy to answer all of your questions. Please write them down in the text. So one step back. So how do you ensure GDPR compliance? This is a general thing we can speak about, because to protect your data and to comply with the GDPR, this is a big concern to all the companies. To implement an adequate data protection concept, you need to first perform, of course, a gap analysis you can do to detect the potential dangers of the GDPR violations. As Rob mentioned, it's very important to know what you're dealing with. What is the personal data you transfer and where are you transferring it to? Then you can and you have to create the registry of processing activities to correctly answer to data subject requests. And of course, for other things, authorities requested, then as we just learned, the legal representative needs it in the EU countries. Then of course it's very important to be aware where your risks are. So you can conduct a risk analysis that helps you to define measures and to close also the gaps you have, because you need to mitigate the risk in the case of data processing. And you also need to define technical and organizational measures that help you to mitigate that risk. So what does the implementation of data protection concept often look like in reality? So I am a DPO and I was before for a lot of companies. So I saw it by myself. Most of the times companies still create the documents in folders. All documents are joined together or lie even with different people. So you don't know where is the document when you're looking for it. Like when you have an audit, for example, a lot of people I see are still working with Excel lists. So they put everything in the Excel list, processing activities, technical organizational measures, and then they are also sent back and forth via email, which can also be very dangerous. And yeah, so you have a lot of risks there because it's unsecured, and you also lose the overview. We had an audit once, and then I was looking for everything, looking up, so it was very time consuming as well. So there are some alternatives there. A software for privacy compliance would be very helpful here, because it simplifies your privacy protection. You have the GDPR compliance, and they help you to ensure that, so that you have all the required documentation and information always available when you need to demonstrate it. If authorities request it, if you're a small company, then most of the times you have the investors requested. Then also you need to get control of the data. As we said at the beginning, you have to know what you're dealing with, and maybe also the software tool asks you questions you wouldn't even ask yourself, you wouldn't look that deep into it. So it helps you also to keep the total control of the data your company is managing and processing, and this also very visual and intuitive. And therefore, there is this, we're speaking about Pradtech now, this legal assisted intelligence solution. So this is our intuitive data compliance workflows. They help you. So we combine basically the legal assistance with a very smart technology in order to help you really to ensure compliance. So therefore, in the program and with Pradtech, you can conduct like risk assessment, impact evaluations, the gap analysis, and you can also create, of course, a record of processing activities, which is the most time consuming in data protection so far. You have everything very visual and in a good overview, so you really don't lose track of where your data is going to. So this is very important, just to be aware of the risks and of the data you're processing in order to not be fined, whether is it outside of the EU or inside. So Yes, you can test PredAttack, of course, yourself. We offer free trial versions. We also offer demos that show you the tool more into detail if you're interested in that. Yeah, please just go on our website and yeah, no, give us a note. So, and now we will see if we have some questions here for Rob. Let me check. So, Rob, I have a question here. This is if the privacy shield will still apply to the UK.
Yes, it will. First and foremost, it's obviously business as usual until 31st of December 2020, or until the transition is extended. I think I didn't really explain Privacy Shield particularly. Privacy Shield is the mechanism, or the code of conduct mechanism, that's been implemented between the EU and the US, as well as Switzerland and the US. And it's fundamentally US data privacy regulations are not compatible with EU regulations, should we say. I mean, they're obviously making great progress with things like the California Consumer Privacy Act and things like that, and there's lots of activity going on in terms of introducing data protection laws into the US. But at the moment, they wouldn't necessarily meet the adequacy criteria, and therefore a particular specific mechanism called Privacy Shield was created so that individual organisations could effectively sign up to a code of conduct, and therefore any data transferred to them from the EU would be processed based on the requirements of that particular code of conduct. So the Privacy Shield exists. That's what enables us to transfer data to the US without having to put those additional controls, the SCCs, in place. But fundamentally, it will continue after the exit date, but each member of the Privacy Shield code of conduct will need to update their public statement, and that statement just basically needs to include the fact that they agree to be bound by the UK as well as the EU. So it's a relatively small textual change that they need to make their public-facing privacy policy or statement. And once they've done that, and of course they keep renewing because they have to annually reconfirm that they are eligible to remain part of the scheme. And I think it's privacyshield.org or is it .gov? It's one of the two that you can go to, and you can check when you do your data mapping and you identify all the various organisations that you transfer data to. You can go to that particular website and you can check to make sure that the organisation you're transferring data to is a member of Privacy Shield, and therefore the additional controls are not required. If they're not a member of Privacy Shield, then those additional controls, those individual controls that you need to put in within the agreement with them, would need to be enacted. But fundamentally, as long as the member has made those textual changes, then it's business as usual, effectively, in the UK.
Okay, good to know. Then we have another question here, and this would be, would we need an EU and UK rep post-Brexit if we do not have an establishment in Europe and in the UK / in the UK?
So yes, so the answer to that at the moment, I mean, this might change as part of the negotiations, but at the moment we have 2 Article 27s, and therefore if you're, for example, based in the US, you are going and you fit the criteria that we mentioned earlier about the type of processing that you're doing and who you're doing it to, then you would need to appoint both an EU and a UK representative. So, and again, that representative would need to be what's called established, is the phrase they use, the word they use, in a member state where you are processing, ideally, the majority of the data. So we come up against this a little bit in that, obviously, if you're let's take a US, I don't know, app developer, you're signing up accounts through iCloud or whatever it is, iStore, and so you might be creating hundreds of thousands of accounts for your app, and of course they're spread across Europe. So at the moment, you can essentially choose your representative to be established in any one of the 27 plus UK member states. it doesn't really matter. But of course, if you're, I think I saw quite a number of pharmaceutical companies on the list joining the webinar today. So if you're conducting, for example, clinical trials, and that trial is only in, I don't know, Poland, then you would need to make sure that your representative is established in Poland. And by established, it means you're supposed to have a physical office, a contact telephone number that is answered in the local language, and a kind of centralized contact point. So it's post and telephone and effectively an address that can be used in that particular establishment.
Okay, so we have the questions, in fact, lining up for you. I shoot just another one, and this is, will I also need to appoint a DPO in the EU after Brexit? So if they need both, maybe, or...
Okay, so you, let's say you're a UK company, you've already got a DPO in the UK. So I think the question is, do you need to appoint another one in the EU? Is that the gist of the question?
Yep. This is what I get from the question, yeah.
Okay. So the GDPR in itself does not state where your DPO must be located, but what it does say is they must be easily accessible from each establishment. So if your DPO is in the UK, as long as they're easily accessible from your offices in Europe, then in theory, the UK-based DPO should be fine. Now, the EDPB has, as I'm sure you can imagine they would do, recommended that you should have a DPO also located within the EU. And so kind of cautious organisations that are carrying out lots of processing in the EU may look to either move or duplicate their DPO into the EU. But on the whole, you should, most smaller organisations that have one DPO at the moment should be able to continue doing so even after the Brexit situation.
Okay. Then we have a last question here that I finished. Ian is asking if there's any impact on certified data erasure.
Certified data erasure. I mean, obviously, if you're talking about the individual's right in terms of the right to be forgotten, then that's not going to change. If you're talking about, I might be interpreting the wrong way, but if you're talking about secure erasure, that's probably a little bit outside of my field in terms of the cybersecurity part. But all of the individual's rights and the principles of both the EU and the UK GDPR will, at the moment, be remaining the same. So whatever you've been needing to do in that respect under EU GDPR, you are also going to need to do under UK GDPR.
Okay. Then thank you so much, Rob, for all this very interesting information. I think everybody learned a lot. I think it was very interesting and helpful for the companies in the UK, but also in the EU. And yeah, I hope speak to you soon. And yeah,
perfect.
To learn more from you.
Thank you so much.
so much.
Thanks so much for inviting me. Take care. Bye-bye.
Bye.